is now in session. Good morning. Today is Court is now in session. Good morning. Today is Wednesday, September 14th, 2022, approximate hour of 9:31 a.m. My name is Buck Allen and I serve as municipal judge. Before the arraignments begin this morning, it is the obligation of this court to advise you of your rights. First, you are presumed innocent. The burden of proof is on the people to attempt to prove the alleged charges against you. This they would attempt to do through the introduction of competent evidence. That competent evidence would come in the form of either sworn testimony or admitted exhibits. Now, the burden of proof that the people must attempt to carry is, as I've indicated, beyond a reasonable doubt. You have the following rights in our judicial system. You have the right to remain silent. You don't need to make any statements, and any statements that you do make, if they are incriminating, can and will be used against you. You have the right to be fully informed of the charge you've allegedly violated. You have the right to be represented by an attorney of your choice. Now, if you are indigent and if you qualify under the state guidelines, you may request the appointment of an attorney to represent you. However, you should be advised those guidelines are rather stringent, and it is hard to qualify for the appointment of an attorney to represent you on the types of cases that appear before the municipal court. You have the right to plead guilty, not guilty, or no contest to the charge you've allegedly violated. You have the right to a reasonable continuance for good cause. An example of that would be to hire an attorney of your choice. You have the right to a trial. Now, that may be either a trial to the court or a jury trial. In order to qualify for a jury trial, you must meet certain criteria. First, within 21 days after entry of a plea of not guilty, you must tender to the clerk of the court a written jury demand. Second, in that same 21-day period, you must tender to the clerk of the court a $25 jury deposit fee. That $25 fee will be kept in the registry of the court pending the outcome of the trial. If you're found not guilty, that $25 fee will be refunded to you. If you are found guilty, however, that $25 fee will be forfeited to the court to help defray the cost of the jury trial. You have a right to compel the attendance of witnesses to testify on your behalf, who otherwise might not appear, through the service of process at no expense to you. If you desire to subpoena such individuals in the court, you would check with the clerk of the court. She'll issue the necessary subpoenas. It will be your responsibility to see that they are legally served. You have a right to enlist prosecution witnesses prior to a trial. You also have a right to copies of any police reports that may have been done on the incident from which the charges arise. Should you desire any of these documents, you would check with the clerk of the court. You have the right to cross-examine any witnesses who may testify against you. Of course, the people have that same right of cross-examination. Thus, if you elect to testify, or if you have witnesses who will testify, the party testifying will be subject to cross-examination by the town prosecutor. Now, as you will recall, one of the first rights we spoke about was your right to remain silent. Opposite that right to remain silent, you have the right to testify on your own behalf. If you elect to testify on your own behalf, however, you would be subject to cross-examination by the town prosecutor. And if you say something that is incriminating, that statement can and will be used against you. Finally, if you disagree with the outcome of the trial, be it a trial to the court or a jury trial, you may appeal the decision on the record to the Summit District Court. Now, in traffic cases, upon a plea of guilty, a finding of guilt, or a plea of no contest, points would be assessed against your Colorado driving privilege. This is done by the Colorado Department of Motor Vehicles. The court has no authority over the assessment of points per se. In the state of Colorado, if you receive 12 points in a 1-year period or 18 points in a 2-year period, you will be called in for a suspension hearing. At that hearing, it is the court's opinion that what occurs. First of all, the hearing officer determines if your record is accurate. Then the hearing officer listens to any explanation you may have for why you received the tickets. Following that, the hearing officer will more than likely suspend your license anywhere from 30 days to 1 year. If you're caught driving on a suspended license, you're charged with driving under suspension. That charge carries with it a mandatory 5 consecutive days in jail up to 6 months and a mandatory $50 fine up to $1,000 fine. Plus, your license will automatically be suspended for an additional year. Yes, ma'am.
We're just gonna try to turn the phone.
Oh, okay. No worries. Hey, perfect. Thank you, Helen. Plus, your license will automatically be suspended for an additional year. So as you can see, it's quite important that you keep track of the number of points on your driving record. Now, in a trial, you may represent yourself, however, people will be represented by an attorney, the town prosecutor. Now, as your case is called, if you go to the podium to my right, you'll be asked if you understand the charge you've allegedly violated. You'll be asked if you understand your rights before this court. You'll be asked if you understand the possible fine and penalty. Before entering a plea, you may ask that the charge be read to you in full. You will then be asked how you plead. At this point, you have a number of options open to you. First, you may enter a guilty plea. You may then explain any facts or extenuating circumstances you feel the court should know before judgment enters. However, you would still be found guilty as that is your plea. Any facts or extenuating circumstances you present to the court would be used to determine what the possible fine or penalty might be. Second, you may plead not guilty. The matter would then be sent for either trial to the court or jury trial, either of which would be set at a later date. Of course, for a jury trial, it will be necessary for you to comply with the requirements to qualify for a jury trial. 2, it would be necessary for the court to empanel a jury. And finally, 3, it is necessary that you have a mandatory pretrial conference with the town prosecutor to ensure there is an issue of fact to be tried by that jury. Trials to the court are normally set at a later date to allow you the same opportunity for a pretrial should you so desire. Third option open to you is that you may enter a plea of nolo contendere or no contest to the charge. This requires the approval of the court is based upon such factors as a previously good record. What the nolo contendere plea means is that you neither assert your innocence to the charge nor do you admit guilt. You merely allow the charge to stand as stated. You do not contest it. For the purposes of finding, a no contest plea is the same as a guilty plea, in that a fine or penalty may be imposed as in a guilty plea. In traffic violations, points would be assessed against your driving privilege. Fourth option open to you is you may ask for a continuance, as has been previously indicated. Now, under the town of Breckenridge ordinances, maximum possible fine is $2,650. Maximum penalty is 359 days in jail. It is most unusual for the maximum fine and penalty to be imposed. It is normally less. For those of you appearing before the court on a penalty assessment ticket, that would be first offense dog at large, most of your traffic tickets, most of your parking violations. You should be advised the court does follow the recommendations on the face of the ticket in assessing a fine. After judgment enters, if it is necessary, if you would make arrangements to comply with the judgment of the court with the clerk of the court, it would be appreciated. The clerk's office should go outside the courtroom, take a left at the top of the ramp and straight ahead is her office. The court does have the power to suspend all or part of any fine or court costs. This is not done, however, as a normal course of events. And you should not plead guilty with the expectation that all fine or court costs be suspended. Finally, you should be advised the court has no monetary interest whatsoever in the collection of any fine or court costs. Excuse me. Now, if you are a non-citizen defendant, you should be advised that a plea of guilty to finding of guilt or a plea of no contest may lead to your deportation, denial of naturalization, or denial of re-entry to the country should you so leave. If you find yourself in this situation and you wish to ask for a continuance to speak with an immigration attorney, we're happy to give you the time. I can't give you immigration advice from the bench. Now, having said that, a traffic ticket is not going to get you deported. A crime of moral turpitude might, such as domestic violence or larceny. Now, if all the charges are dismissed against you, you do have the opportunity to have your file sealed. This is done through a written request to the clerk and payment of a $65 fine. Now, if you received a penalty assessment ticket, that'd be first offense dog at large, most of your traffic tickets, most of your parking violations, you should be advised the court does follow the recommendations on the face of the ticket in assessing the fine. Now, when you were given a penalty assessment ticket, that's a traffic ticket, you were told you could pay the fine and get a 2-point reduction. If you wish to take advantage of that opportunity today, that is available to you. You can enter a plea of guilty or no contest and get an automatic 2-point reduction. If you wish to plead not guilty, I will give you your file, you go speak with the prosecutor, and then you'll come back in here. Okay, we will now proceed with the arraignment process. Because we have a limited number of people here, we'll kind of go in the order that you arrived. Sir, I think you were here first. You want to come up to the podium, and what is your name and what
My name, I go by Chris, sir. I'm the administrator for the account in which...
excuse me, what is the name of the defendant?
The citation number is 68851.
Okay, what is the name, please?
The name on the account is Chris Anderson.
Okay, and what kind of ticket is it?
It was a Breckenridge, town of Breckenridge traffic citation with an assault charge on it.
Okay, I've got your file here. In People v. Christopher Anderson, sir, it would appear that you are charged with allegedly violating Town of Breckenridge Ordinance 6-3C-1, disorderly conduct fighting, Section 6-3A-4. It looks like harassment, kick, strike, and shove. Section 6-3F-16, open container. Each of these violations occurred on June 23rd at 10 a.m. at 200 Ski Hill Road. Each of these charges carries with them fines of from $0 to $2,650, 0 to 1 year in jail. Do you understand your rights before this court?
Sir, can I ask the court to take judicial notice of American Jurisprudence, Book 16, Constitutional Law section?
Actually, if you wish to make a motion, you may file it in writing. And at this point, what I wish to do is ask you if you understand your rights before this court.
Well, sir, I do not understand my rights as the administrator over that account. I do not understand, or I do not believe that I believe the court lacks jurisdiction, and I would like to see the jurisdiction.
Well, I am certain that you can file a motion setting that forth, and we will have a motions hearing on it.
Well, I believe the court currently lacks jurisdiction, sir, and I would like to see the supposed jurisdiction.
You need to place that motion in writing. I will enter pleas of not guilty for you on the charges.
You're practicing from behind the bench, as I did not plead not guilty for that.
Okay,
I did not enter a plea,
very
sir.
well, we can continue the matter, and you can file a motion with your matters. And what we will do.
So this court is moving on facts that are not in evidence currently?
I'm not moving on any facts that are not in evidence. What I am doing is continuing the matter.
I do not consent to continuing the matter.
Well,
As the administrator for the account, I am a man and I am competent. I am here under duress. I do not consent to this matter. If I am here at all, I appear in special appearance to challenge jurisdiction and have this matter dismissed.
And I have told you that to challenge the jurisdiction, you need to file a written motion. We will set this matter.
I do not consent to that, sir.
Pardon me?
I do not consent to that, as I cannot rebut an unstated presumption. As a man accused by your laws,
There is no unstated presumption here. We are going to, you will file a motion.
I do not understand what filing the motion is. I'm
That
here right
means
now,
you-
sir, to have this matter
Excuse
dismissed.
me. You need to place your motion, your objections in writing to the court. And we will have a hearing on your motion, which is what you are trying to do now, but the prosecutor needs to be advised on this, so the prosecutor may argue the motion, as you are trying to argue your motion now. So what we will do is we will continue this for a motion hearing to September 28th.
I have another court hearing on the 28th of September, sir, in El Paso County.
Well, the
And
20th of September is not the 28th of September.
I said the 28th, sir.
Well, you said the 28th?
Yes, sir, I did.
Then we'll continue this to the 10th of,
I have a trial on 10th of October, sir.
okay, then we'll do it on the 12th of October. And we'll note defendant to file motion. We'll order that you file your written motions. And we will set that for, you will have your written motions filed by the 28th of September.
And does this go for the same as the prosecution? They have to have theirs filed and also served to me?
They will, the prosecution will be entitled to make a, they will file with the court and send to you their response to your motions, prior to the 12th of October.
And so for their,
next court date.
I'm sorry, can I ask one question? Because I don't understand how they're going to go ahead and wait for myself to present, the administrator to present a motion to the court.
Well,
Yet their
because they
evidence
don't-
is not going to be
they
presented to
don't
me
know.
so that I can go against
Excuse
their
me, let
motion,
me
sir?
finish. They will not know what you are going to file.
And neither will I,
until
sir.
it is filed in writing on that date, the 28th of September.
And neither will I. I do not know what they are going to file so that I can properly allege the charges against
Well,
them. So how am I,
you will
they
it
get special
prior
charges?
to That date on the 12th of October. If If you'll please take this to the clerk, she'll process you through.
Thank you, sir. I'm done.
Take care. Sir, you'll take your file. Then she will give you a report for October 12th. You have a good day.